We've all heard this statement before: the family courts are biased towards women. From a lawyer's perspective, the courts are not biased towards women. The reason for the confusion is because of the complexity of the decision-making process. This is best understood through a couple of common examples. The first example is financial cases where one party was the homemaker, usually the woman, and the other party, the breadwinner, will almost always result in the homemaker receiving a larger portion of the assets. If we look below the surface, there are two considerations that are relevant. The first is the value of the parent and homemaker contribution, and the second is the future needs of the parties. When a court looks at a spouse's parent and homemaker contribution, depending on the length of the relationship and variety of other contributions, they value the efforts made by that spouse in maintaining the household and caring for the children as equally important to that of the breadwinner in earning an income. When the court looks at the position of the parties moving forward, they want to make orders that give the parties a clean break. They want the parties to exit the relationship on as equal footing as possible. The second example is an interim hearing where the court orders that the children live with the mother and spend every second weekend with the father. The question that arises at the surface is, there are two parents, so why shouldn't the children spend equal time with each? Once again, if we look below the surface, the following considerations are relevant. 1. What are the children's needs? 2. What will be least disruptive to the children's current lifestyle pending a final hearing? 3. What are the capabilities of the parents to care for the children? 4. Protection of the children against allegations of risk. And 5. The nature of an interim hearing compared to a final hearing. In understanding why a court makes an order, it's very important to understand the purpose of an interim hearing. An interim hearing is a preliminary hearing to set temporary arrangements in place pending a final hearing. Interim hearings are quick and dirty. Judges are not looking to make the right decision, they're looking to make the safe decision. The least risky option is usually the one that maintains the status quo. This is simply because there are less unknowns. The court's decision-making process is very thorough and nuanced. Even the examples I've given are oversimplified. When we don't understand something, we have a tendency to just throw our hands up and make general statements like, well, the family courts must just be biased towards women. Don't fall into the trap of assuming that you understand the family law. Always question the experiences of family and friends, and engage an expert family lawyer as early as possible in your matter.